LA hotel minimum wage requirements. Panic buttons. So every employee that is assigned to a guest room or a restroom where other workers are not assigned to be present needs to be issued a panic button. And you should think about this broadly. You may think it's public area housekeeping and room attendants, but your engineers go to rooms unescorted, and any other employee who might go to a room unescorted, like a room service server. Maybe in the smaller properties, you have a manager that might deliver things to rooms and enter the guest room. To the extent he or she goes up there alone, they should be issued a panic button. So what is a panic button? It is defined in the statute as a portable emergency contact device that needs to include a location tracking element, and also facilitates communication between the individual who's activated the panic button and the security or manager who is charged with responding to those alerts. The alert must go to a designated security guard or a trained supervisor. And here's a distinction depending upon the number of rooms at your hotels. For hotels with 60 or more rooms, the report must go to a designated and assigned security guard. And that security guard needs to be able to respond immediately. What that means is you can't say manager X is going to be our security guard. You need to have a security guard. We think you can still have third-party security guards, but you have to have someone that is a security guard that's designated and to respond to panic button alerts and who can respond immediately and is on scene. So it can't be a remote security service. For hotels that are less than 60 rooms, you can designate an assigned manager or supervisor to be the person that receives the alerts and is charged with responding. But before you can do that, that supervisor or those supervisors or managers need to have at least 3 hours of training, and the content of that training is laid out specifically in the ordinance. There are other requirements relating to the rights of individuals who experience violent or threatening conduct and trigger an alert. An employee who does so and experiences violent or threatening conduct is entitled under the ordinance to paid time off immediately to go see a counselor. Counselor is not defined. We hope that that'll be defined in the regulations, but they need paid time off immediately to go see someone. In addition, the employee cannot be discouraged from making a report to law enforcement. You also can't insist that they make a report to law enforcement, but either way, the decision is theirs. You can still call 911. You can make a criminal report on behalf of the hotel, but you can't compel the employee. The employee requests reasonable accommodation, just like under the ADA or the California Family Rights Act. You need to provide reasonable time accommodation, such as some time off, potentially maybe changing the shift so he or she feels more secure, at least until the period of accommodation lapses. There's a very strong no retaliation provision. You can't retaliate if an employee decides to use the panic button, as long as it's not completely in bad faith. You also can't discourage them, as I said, from reporting to law enforcement, can't retaliate either. There's also specific annual training requirements for employees, how to use the panic button, the company's process for how it's going to respond, who's going to respond, and then training on what employees' rights are. Before I turned it over to Jeff, I did want to mention that a number of insurance providers in this space, for an appropriately functioning panic button that has all the bells and whistles, are prepared to give some form of reduction in your GL rates.
Now, given that panic buttons are a very complicated and new type of technology, so we have Jeff Engel with Location Tech on hand to explain to us the different types of panic buttons, what to look out for, how they function, and what your options are. Go ahead, Jeff.
Yeah, thanks, Keith. Thanks, David, for switching over. So if you look at the space, the solutions are broken into 3 different groups. One is just very similar to what Google Maps is, where you push a button and you know where you are 2-dimensionally. No 3-dimensionality into the space. And then there's a second set of providers which give you some location, about 70% accurate, meaning they get 30% of the time they give you the wrong floor or wrong room. And then the third set is where it's a part of a system called RTLS, or real-time locating services, and that's where you're getting room level accurate, not only floor but room level accurate. Next slide, David. And so when we as a group talk to customers, they say this, and about half the customers we talk to are excited about, well, actually probably about 10%, are excited about this legislation because they're saying we're already doing this and we think it's a good deal. And the remaining 90% are like, I'm being overly burdened with another step. And we'll flip the conversation saying, since you have to do this by law, why not leverage the platform? Because once you install a wireless platform, you can expand. And this is why Towers, the insurance group, is on here, is because once you put the panic button in, you can add other use cases to you. So as an example, you may have a problem with the flooding from guests leaving bathtubs, letting them overflow. You can have devices that'll signal immediately. You may also have, because the law has, or the ordinance has requirements to have security guards on premise, you may want to be able to document their movement. And documenting their movement is different than what the panic buttons are doing, because part of the mandate, which hasn't been declared yet, but it will be, it's been declared in everyone else, is you cannot track hotel workers. So what we say is they're invisible until they push the button. Where your security personnel, you may want to have them checking on rounds, as there's different parts of technology. So when you look at what you're doing, you can either go for something that solves just the problem for today, or you can put it in a platform that allows you to not only solve today, but grow for the future and add these use cases in.
Excellent. Now back to you, Keith.
Sure. So back to some of the additional requirements in the ordinance. There's a specific requirement that that signage be placed on the back of every guest room and restroom door in the hotel. And what's important is that the ordinance specifies the font size and the specific text that needs to be in the message. You don't want to vary or order or augment it in any way. You want to be specific. And I think Jeff and his company, as part of their provision of the panic button system, they're familiar with these provisions and can assist with the requirements if needed. So what I consider to be the absolute most onerous and costly aspect of this ordinance are the housekeeping workload restrictions. In essence, the law creates a double time penalty for all hours worked whenever a housekeeper exceeds the square footage limits in a day. So if a housekeeper works 8 hours and cleans 1 square foot more than the ordinance allows, all of those 8 hours need to be paid at double time. So it's a significant penalty. For hotels of 45 to 60 rooms, the square footage limit is 4,000 square foot per day for a full 8 hours of work. For hotels with 60 or more rooms, the square footage limit is 3,500 square feet a day. In addition, there are 500 square foot reductions under a number of circumstances. So you go from 3,500 to 3,000, potentially even less, as I'll explain. So any combination of 6 checkout rooms or what they call additional rooms, but really what additional rooms are rooms with rollaways and cots. So if you have 3 checkout rooms and 3 rooms with rollaways and cots made up by a single housekeeper, you need to reduce your square footage by 500 square feet. Similarly, if they have some combination of checkouts and rollaways that equal 7, that's 1,000 square foot reduction to their daily square footage allotment. There is an ambiguity here. The question is, if you have 5 checkout rooms and the 6th one has a rollaway and cot, is that a 500 or 1,000 square foot reduction? I think right now the safer course is to reduce 1,000 square feet, but we hope this is one of the ambiguities that's cleared up when the city issues regulations. You also reduce 500 square feet when a housekeeper cleans in more than one building and when a housekeeper cleans on more than 2 floors. In addition to these reductions, there also is a potential reduction pro rata based on whether the housekeeper works less than 8 hours in a day. So for an 8-hour day, you get the 3,500 or the 4,000 square feet. But if they only work 7.5, then those square footage thresholds are reduced pro rata by the amount of time they actually work. In the LA ordinance, there's also this one little gift where if an employee works more than 8 hours, and they can work up to 10 without consent, you actually prorate up. So if your normal workday is 8 hours and they work 10, you can add additional 25% to the square footage. Last thing I'll mention, this is a big issue and one that you should check with your in-house counsel or outside counsel because there's an ambiguity and it really is an issue of risk tolerance. And that is, how do you treat paid meal periods and rest breaks? So if your employee is scheduled for 8 hours, they have 2 rest breaks by statute that are paid, but they're obviously not working during those rest breaks. And if they have a 30-minute meal period, they're obviously not cleaning rooms during that period. The question is, do you have to reduce the pro rata square footage? I think the general consensus is no, but that's an open question, and it is a risk if you don't prorate until we get some clarity from the city. Then what I've called the gag order. This law requires each hotel to clean every room every day unless the guest affirmatively tells you without any solicitation, meaning your front desk people can't ask, that the guest doesn't want daily housekeeping. You can't provide points, you can't provide a financial incentive for your guests to pass on daily housekeeping. Waivers. One waiver is basically an inability to pay. You have to petition the city to show that if you comply, you'd have to file bankruptcy, you'd have to shut the hotel, you'd have to reduce your staff by 20% or hours by 30. The other waiver, and this is the gift and the union's angle on this, in order to waive, for example, the square footage requirements, you'd have to get a clear and an unambiguous waiver in a collective bargaining agreement. The damages are significant, in addition to actual damages. For those of you who've had the pleasure, and I say that sarcastically, of having a PAGA action, the penalties are similar. They are $100 per employee per day. Record keeping violations are capped at $1,000 a day. But if an employee, there's a private right of action. If they find counsel, you pay for their attorney's fees and costs. And for willful violations, damages are trebled, meaning you pay 3 times the underlying award in damages. Last, and I'll close with this and then open it for questions. For those of you who are hoping that AHNLA or CHNLA or the HALA is going to come to the rescue and bring a legal challenge, my take is that that's unlikely. And even if it was forthcoming, given some of the legal challenges in the past, it would be a significant undertaking in order to prevail in such an action. So with that, I'll open for questions.
Okay, great. At this time, if you'd like to ask a question, you can do so using the chat, and everyone can also see that live. We have one question already, and I'll just read that off while you're considering or typing away. And the question comes from Sashi Pujal. We will have some late night room cleaning needs like 500 square feet. Can we have public area attendants clean the room and still continue the public area?
So the answer is it should be that you can do that. Housekeeper is defined, room attendant is defined in the statute, and the square footage limits expressly apply to room cleaning. So it should, the square footage that a public area housekeeper has to clean, whether it's meeting rooms, public spaces, whatever, should not count as square footage. But that is an ambiguity that's out there. But I think my interpretation of the statute is you can certainly have a public area housekeeper do an extra 500. They could actually probably do more than 500 square feet. They could probably clean a couple of rooms without becoming a housekeeper subject to the regulations. Next question I can see is, when should we expect the LA City to put out regulations? In the normal course, you would have liked to have seen regulations out already. Given the speed with which this legislation was passed without any debate, without any economic impact analysis. So far, the HALA has engaged with the city, and they say it's forthcoming, but this city doesn't move all that quickly, and they've got 2 weeks to get out regulations. I somehow doubt they'll be out in time. Hopefully, they'll at least issue some unofficial guidance on some of these critical ambiguities. As far as an arbitration agreement, that's an interesting question. If you have an existing arbitration agreement, obviously you still have to comply with all the requirements of the statute. And what an arbitration can't preclude is an employee going to the DLSE for enforcement. That couldn't be in an arbitration agreement. And you can include a class waiver, a PAGA waiver, but that law, and that's a subject for an entirely different webinar about where we stand given the recent Supreme Court decision relating to PAGA actions and class waivers.
Next question is 3,500 square foot footage, approximately 11 rooms. How many checkouts and how many stayovers?
So stayovers, you can clean, you could clean 11. There's as long as, again, none of the other square footage reductions apply. So the housekeeper's only on 2 floors, not 3. All the rooms are in one building, and there are no cots or rollaways in those rooms.
And then Gretchen asks, I understood that if a stayover room had no service the day before, it is considered a checkout?
That is a good question. There are these special service rooms, which are the extra dirty and where service has been passed. You can send us an email and I can confirm what the scope of these quote unquote special service rooms, but whether it's one night of passing on service or whether it's got to be more than one night, there is a specific provision in the ordinance itself.
Next up from Ruella, an RA has 4,000 square feet and finished cleaning in 6 hours. Does she get paid for 6 hours or 8 hours?
So the challenge is if she has finished 4,000 square foot in 6 hours, she's exceeded the square footage limit because it's prorated. If your assignment was that it should take 8 hours to do the 4,000 square feet, that's fine, but she should not check out. You should assign her other tasks, and there are some specific tasks that are listed in the ordinance that don't count as additional square footage. So stocking a cart, getting the cart set, those kinds of preliminary type stuff. And then you could assign that person other work that's not cleaning. So you couldn't send her to do public area cleaning, but if you have a laundry, he or she could fold laundry. If there are other tasks that can be done. Otherwise, you're better off having her sit in the cafeteria for 2 hours if there's nothing else for her to do that's not cleaning work. Again, because if she clocks out and it's only 6 hours, all those 6 hours are double time.
Okay. Now, Paul asks, if a hotel over 60 rooms does not currently have security, but has workers going to guest rooms on all 3 shifts, does the hotel now have to hire 24/7 security?
By the terms of the ordinance, the answer is yes. They have to retain. So either they hire it as security guards as proprietary security, or they contract with a third party for security, but it can't be remote. They have to be on site. They have to have someone specifically designated 24/7, or at least whenever you have people that go to guest rooms, that are prepared to respond promptly to any activation of a panic button.
Okay. And now let's move on to Sue. If my employee goes over the square footage by the 8th hour, can I prorate up by adding prorated square footage and pay just time and a half for an additional hour?
So if I understand the question, the employee was assigned 3,500 square feet, but didn't finish until 8 hours and 20 minutes. The answer is yes, you can certainly prorate up by that 20 minutes. And then it's 20 minutes of daily overtime. And as long as the numbers work and you didn't exceed the square footage, there's no requirement for the double time penalty.
Okay. And then we're going to move on to Manny that says, what if our area there has no security guard service?
Well, if you're a hotel under 60 rooms, you'll have to designate a manager or supervisor. If you're over, you'll have to hire somebody, or find a. I mean, there are services virtually everywhere, and I suppose that's a one-off question that you could ask the city if there was no conceivable way to hire a security guard.
Okay, that takes care of our Q&As. Ruella, you had another question regarding the 4,000 square foot scenario with your employee, but I think Keith answered it. And
Before we go, I have the answer to the earlier question about the special attention room. It is a special attention room is either a checkout room or a guest room where the guests decline room service or room cleaning on the preceding day. So it's only one day. So if you have some combination of 6 pure checkout rooms and rooms where the guest had declined service the day before, those 6 count toward the threshold of whether you reduce by 500 square feet.
Okay, that concludes the time we had set aside for this webinar today. And I really appreciate everyone for coming and participating and asking your questions. Just reading Gretchen's comment, ugh, Keith's last answer. The ordinance in general is probably bringing about that emotional reaction in everyone. It's a lot to do, a lot of costs, a lot to consider and adopt in a very small amount of time. Thank you, City of Los Angeles. For additional answers to your questions regarding labor and law and employment, please contact Keith with Hirschfeld Kramer, and you can get your individual questions taken care of that way. If you have questions regarding panic buttons, the technology options, what's right for your facility, contact Jeff Engel with Location Tech. And if you have questions regarding risk and commercial insurance and how these statutes and how panic buttons can affect or possibly even lower your rates, please contact Shaq Heaps with Tower Street Insurance. Their contact information is on your screen, and again, will be available in the slide presentation that will be emailed to all of you afterward. I thank everyone for attending today. This has been a short but very informative session. We thank our guest experts for their time and attention, and good luck to everyone in adopting these new ordinances and moving forward. Thanks for attending today. Have a great afternoon.